In recent years, we've seen a rise in what's called the gig economy. And basically, what this is businesses that are sprouting up and taking advantage of workers who are classified as independent contractors. A perfect example of this is Uber or Lyft. So essentially, someone is able to work whenever they want. And this classification of workers, independent contractors, has been around for a really long time. Historically, according to the IRS, the two types of worker classification is either employee or independent contractor. Now, with that, typically an independent contractor is someone who is of professional level status. What that means is that we've seen them in cases such as lawyers or dentists or anybody who has a professional level education or certification. That also includes athletic trainers. I am a huge advocate of independent contractor work because it's a way that I've been able to grow my business, but it's also a way that I've been able to expose myself to professional arenas and settings that otherwise wouldn't be available. I think that majority of our profession has grown into the areas that it has, be it performing arts or rodeo or military or any number of the other areas, industrial, as a result of people being able and willing to accept independent contractor work. Now, there are very specific rules and regulations that surround the way that someone is supposed to act and be treated when they are operating as an independent contractor. And so I want to do this video for you to help you understand how to protect yourself, but also how to recognize when you're being treated as an employee versus an independent contractor. The first thing that we need to know in understanding what an independent contractor is the definition. And this is how the IRS deems someone to be an independent contractor. The general rule is that an individual is an independent contractor if the payer has the right to control or direct only the results of the work and not what will be done and how it will be done. That's very specific because next I'll talk about the 3 common law rules. And those get into financial and behavioral and the type of relationship. And what that means is that if someone is working as an independent contractor, so either if you're employing one or if you're working as one, the person you are working with should not be able to direct the way that you're doing work. What that means is they cannot institute any training, they cannot require any training. You have to be willing and able to show up and do your job with no additional skills or training provided by that organization or employer. This is very important. And this is a perfect example of how Uber is able to keep their drivers as independent contractors. They don't have to be trained how to drive. They already know how to. They show up at the job knowing how to do it. And so do athletic trainers. Now, this isn't the same as potentially needing to be trained on how to use or understand a specific software or a certain type of form that someone might want you to use. That's not the same as actually having to be trained to do our job. So let's look at the 3 common law rules that the IRS uses in order to determine if someone is being treated as an independent contractor or an employee. The first common law rule is behavioral, and they define that as, does the company control or have the right to control what the worker does and how the worker does his or her job? So we've basically already covered that. The next one is financial. Are the business aspect of the worker's job controlled by the payer? These include things like how the worker is paid, whether expenses are reimbursed, or who provides tools and supplies. Now, this is a very important distinction for you to understand if you're working as an independent contractor. You are not going to have access to any type of normal financial things that you might be considering from an employer. This includes retirement plans, health benefits, any type of other type of compensation out of simply the pay that is agreed upon to do the job. Now, with that, they also are not responsible for taking out taxes. So if you receive a payment that has had either state or federal or unemployment or workers' comp or anything taken out of it, that is an indication that you are being treated as an employee, not an independent contractor. As a result of being an independent contractor, you then are responsible for paying taxes on those monies after the fact. There's all types of information that you can find in way of deduction so that you can reduce that tax liability. And I'll probably do a separate video on that at some point. But know that you will eventually have to pay taxes on that. It's just not taken out upfront by your employer or the organization that you're working with. Now, the third common law rule is type of relationship. And the IRS defines that as, are there written contracts or employee type benefits? Will the relationship continue, and is the work performed a key aspect of the business? Now, this is important because I'm a huge proponent of getting written contracts up front, and everything in those agreements should indicate that you are an independent contractor. In no way should there ever be the word employee, employer, unless it is distinguishing that this is not an employee-employer relationship. Now, if we take that a step further, in regards to the relationship, there should also be terms and terminations. Typically, this type of relationship is not something that is ongoing indefinitely and something that either person would be able to get out of. Mostly these are specific terms, so a single event, a single year, a single type of coverage that you're going to be willing and able to provide, or entering into a relationship with this organization. And even if you do have an ongoing relationship with that person, the agreement should indicate that there is some type of term to it. Now, if you are deemed an independent contractor, but the work that you are doing is a key part of the business, the IRS may determine that your work as that independent contractor should actually be considered as an employee. Now, the entire understanding of this in regards to the IRS can be thought of like a scale. So if we have a certain amount of indicators of employee and a certain amount of indicators of independent contractor, each time you ask a separate question, it's going to get weighed one way or the other. So if you're offered a retirement plan, that's going to go in way of an employee. If you are getting on-the-job training, it's going to go in way of an employee. And so there is no one necessary distinction that is going to indicate if you're one or the other. They all are taken into consideration to determine if you're treated and if you should be considered an employee or an independent contractor. Now, that's important to understand, because if just your agreement or your contract with an organization says you're an independent contractor, but the way that they treat you and the way that they pay you is that of an employee, it could start to get weighed the other way. So just putting it down in writing isn't enough. We actually have to treat each other as independent contractors. Misrepresentation of employees as independent contractors is a big issue for the federal government, namely because they think that people are purposely trying to skip out on paying taxes, employment taxes specifically. And so there are some organizations that will purposely misclassify you as an independent contractor because they don't want to pay employment taxes. And there's certain organizations that simply don't understand the nuances and all the differences between being an employee and an independent contractor. There is an IRS form, SS8, I will link it up above, that if you feel you have been misrepresented or simply you want to more deeply understand the way that the IRS would consider if someone is an independent contractor or an employee, this is a fantastic form because it asks a ton of questions that really gets you thinking along the lines of how should I be treated in one situation versus the other, and how is it that I need to direct myself in my own work if I do want to be treated as an independent contractor. So lots of resources out there. The federal government, IRS, is a great place to start. I will link majority of this information down in the show notes so that you have them. But overall, the understanding should be that there are a lot of great perks and opportunities to being self-employed, which is working as an independent contractor. And there are ways to take advantage of taxes and different write-offs that are normal and within your scope of just operating as a self-employed individual. And so if you come upon an opportunity to work as an independent contractor, make sure that you're educating yourself. If you can, speak with a tax professional and set yourself up for success in making sure that the treatment that you're given and the way that you are regarded in your employment is actually accurate and representative of being the independent contractor.